Hi, I'm Denise, and you're watching Law with Denise. This is a case summary of the House of Lords decision in Alcock and Chief Constable of South Yorkshire, 1992. In this video, I'll go through the facts of the case, and I'll go through the decision reached by the House of Lords in this particular case. At the end of the video, I will also discuss the significance of this decision reached by the House of Lords. So, what exactly happened in Alcock and Chief Constable of South Yorkshire, 1992? Well, the case was a test case which involved plaintiffs or claimants who were relatives of people who were injured or died in the Hillsborough disaster on April 15, 1989. And this disaster occurred at the Hillsborough Football Stadium in Sheffield, in England. Now, the plaintiffs were not actually injured themselves, but they witnessed their relatives either being injured at the stadium or either with the knowledge that their relatives were in the pen that the disaster was occurring in, or in some cases, plaintiffs viewed the disaster on TV or heard it on the radio, and in some cases, plaintiffs went to view their relatives' bodies at the mortuary after the incident. All these plaintiffs, as a result of the witnessing of either the incident or the witnessing of their relatives after the incident, developed psychiatric injuries. They claim that the police force, notably South Yorkshire Police, should be responsible for recovering damages for their psychiatric injury because it was the police that caused the disaster in the first place. And the police, it was agreed, caused the disaster as a result of their negligence. So their argument was that, oh, the police were negligent and this negligence led to the disaster. And as a result of viewing this disaster, which affected my relative, I now have a psychiatric injury, and it is the police that should recover damages, should give me damages for this psychiatric injury. And they argue that in order to get these damages, the only thing that the court should examine was whether or not it was reasonably foreseeable that they would suffer injury as a result of the defendant's negligence. So they argue that it was a foreseeability test which was to be applied, and that if that test was successfully applied, then they would get damages from the police force. Now, in response, this is what the House of Lords said. The House of Lords said, no, it is not just a simple matter of applying the test of foreseeability. We're not just going to ask, was it reasonably foreseeable that you would have suffered the injuries you did as a result of the defendant's negligence? The court said, with regard to secondary victims, which is what the plaintiffs were, because they were not participants in the incident, but they were witnesses of the incident, in their case, as secondary victims, the House of Lords confirmed that it was control mechanisms which were going to be applicable. People would need to pass these control mechanisms in order to successfully recover damages for pure psychiatric harm. And the court confirmed that the control mechanisms were proximity of relationship, proximity of time and space, and proximity of perception. Now let's explore what each one means. The first one, proximity of relationship, is concerned with the relationship between the secondary victim and the injured party. The court has to be convinced that there is a relationship of close tie and affection before the secondary victim can pass this control mechanism. Now, in some relationships, the court presumes that there is a close enough tie of love and affection. If it is a relationship between parent and child, and if it is a relationship between spouses, the court presumes that, yes, there is this close tie of love and affection. In those relationships, in those instances, the secondary victim will pass this control mechanism. However, in other types of relationships, such as those involving siblings, so brother and sister, brother and brother, or grandparents and grandchildren, the court does not have this presumption. So, with siblings, they have got to convince the court that their relationship was one of close tie of love and affection. So that's the first one, proximity of relationship. The court is concerned with how close was this secondary victim to the injured party. They want to see that there's this closeness before they are convinced that they should even consider giving you damages. Now, the second one is proximity of time and space. And here the court is concerned with where the secondary victim was when the incident occurred. And they're also concerned with the circumstances, depending on what the facts of the case are. So what we mean is, yes, if the secondary victim was at the incident and they saw what was happening, so they saw the accident, they should pass this control mechanism. But the court also said, if the secondary victim wasn't actually there, but they viewed or heard something after the incident, then they could also pass a control mechanism. So the court is accepting of the fact that you might not be at the accident at the time when your loved one is injured or killed, but you might turn up hours after and see their body or see them in a state. And this viewing of them afterwards could lead to a shock, which could lead to psychiatric injury, and you could still pass this control mechanism. Unfortunately, in Alcock and Chief Constable of South Yorkshire, the plaintiffs were not able to pass this control mechanism when some of them said they viewed their relatives 9 hours after the incident at the mortuary. But nevertheless, the second control mechanism is one of proximity of time and space. The third one that the House of Lords outlined in Alcock and Chief Constable of South Yorkshire was the proximity of perception. And here we are concerned with how the secondary victim heard or saw the incident, and we're also concerned with whether or not the secondary victim actually heard or saw the incident. So, firstly, it is important that the secondary victim actually heard or saw the incident. You will not pass the control mechanism if someone just told you about it. And what I mean is someone told you about it, but you didn't actually go and look afterwards. Someone can tell you about the incident, that something has happened to a relative, and then you go and have a look, and you can still pass the control mechanism. But if you were just told and you never actually saw your relative in the incident or saw them afterwards, and you are claiming that you are in shock from hearing from another person what happened to your relative, you will not pass this control mechanism. Another element to this control mechanism, which is one of proximity of perception, is, as I said, where or how you heard of it. And what I mean by that is you need to have seen it with your naked eye or heard it with your ears. Say, for example, you have seen the incident on television, as in Alcock and Chief Constable of South Yorkshire. Some of the plaintiffs actually saw the incident on television, and the House of Lords said that was not sufficient to pass this test of proximity of perception. So there we have the facts of the case, and we have the control mechanisms outlined by the court. And then finally, let's look at the reasons why this case was so significant. Firstly, the courts explained the differences between primary and secondary victims. So they confirmed that primary victims are those who are participants in the dangerous incident, and secondary victims are those who witness or hear of the incident or hear the incident. And then they told us that it was not just the test of foreseeability which was applicable with regard to claims for damages for secondary victims. They told us that in order for secondary victims to recover damages, they needed to pass all three of the following control mechanisms. Those are proximity of relationship, proximity of time and space, and proximity of perception.